Texas Law School join me. One is from the right, Jonathan. One is from the left, Stephen. And let's get first your reaction to the leak, then your reaction to the draft opinion in Dobbs. Steve, let's start with you.
Well, I mean, Hugh, I think the first thing to say is it's now pretty clear that we're talking about more than one leak, right? That in addition to the draft opinion that Politico circulated last Monday, we now have the story from the Washington Post last Saturday reporting directly on the internal deliberations at the justices' private conference in December and attributing that report to someone close to one of the court's, quote, more conservative justices, unquote. And we have this additional story from Politico this Wednesday, reporting on follow-up proceedings within the court, what's happened since that draft opinion was circulated in February. So I think that's relevant, Hugh, because it suggests, first, that we're talking about more than one leak, and second, that at least one of the leaks is coming from, contrary to what so many folks on the right have been saying, the more conservative justices. I don't think that proves this is all coming from the right, but I do think it rather complicates the narrative that this is some pressure campaign being mounted by the left.
Jonathan.
I think the leak is very disturbing. There occasionally have been leaks and rumors from the Supreme Court. There has never before been the leak of a draft opinion on a pending case. It is unprecedented. It is something that threatens the ability of the justices to be able to deliberate, to be able to consider and evaluate arguments as they are developing the opinions that are going to bind the country. I think what's more important than who the source of this leak was, whether it was someone from the right, from the left, someone else that really has no political agenda, whatever, a leak of this sort is really corrosive to the ability of the court to do what we want and need it to do. And it's tremendously unfortunate, whatever one thinks of the content or the motivation of the leaker, it's terribly unfortunate that something like this happened.
I had lunch this week with a Supreme Court clerk who's risen, of course, in the law since then. I clerked on the D.C. Circuit, not the Supreme Court, so I know what the confidence level in the clerk's ability to maintain confidentiality was, and at the court it's even higher. This clerk expressed sadness, but also an anticipation that this was going to become more routine because the times they are changing. Steve, do you agree with that?
I do, Hugh, and I think Jonathan's absolutely right that none of this is good for the court as an institution. I mean, I don't think anyone, regardless of their views of the court, can really dispute that. I will say that I think it's worth not disaggregating the fact that this is all happening in Dobbs, and the fact this is all happening with regard to a draft opinion that if it ends up substantially the same when it's handed down formally, would be an absolute earthquake. I think some would say for better and some would say for worse, but an earthquake nonetheless, not just for abortion rights in this country, but for how the court is perceived by the public, for how the court approaches unenumerated rights in general. And so, Hugh, for me, the leaks, plural, are a deeply disturbing reflection of where the court is, not just for the reasons Jonathan mentioned, but because the fact that it's happening in this case particularly reinforces how even on the inside, folks understand that this is an enormous deal, not just in how the court rules in Dobbs, but actually that the court is going to apparently rule the way it's going to rule.
If you just tuned in, I'm talking with Professor Jonathan Adler of Case Western Reserve Law School and Professor Steve Vladeck of the University of Texas Law School. Jonathan, earthquake is the analogy I use, not only because it does shake everybody up, but it also passes very quickly. I think if this majority opinion draft becomes the majority opinion, it's quite likely to be of significance in law school classrooms for a long time, but it's actually not going to change facts on the ground much. What do you think?
Well, I mean, I think that depends on the region. I mean, I think I have more expertise on the law than on the on-the-ground politics. I know here in Ohio it'll mean that politicians can't posture on this issue in one direction or the other, but they'll actually have to think about what sorts of laws relating to abortion they want to support, because those laws will have an impact. Now, I happen to think that that's actually politically good, that being able to posture on very important issues and not actually having to legislate and deal with one constituent is corrosive to the democratic process. So I think it's good that issues like this have to be dealt with politically. But whether or not that has a broader effect on who wins elections or not, I think we'll have to see. And legally, I think that it will. The earthquake analogy is right in part because, as the opinion notes, Roe and abortion cases have had a corrosive effect on other areas of law because of the felt need to try and protect that holding. And I think eliminating that will actually help in a wide range of areas of law courts do what they're actually supposed to do and get decisions right.
Steve, I want to ask you, as the center-left commentator, I have long advocated for a Dobbs-like decision because largely Reagan and George H.W. Bush won their elections because people expected from them justices who would put Roe back into the box. Instead, they got the joint opinion in Casey. And I think it shattered a lot of credibility on the right. If this court does not do, after 3 appointments, what Trump campaigned on, which is to get rid of Roe and return it to the political process, I think you lose half the country's confidence that the court is other than a blue bubble factory.
I mean, that's pretty ironic, Hugh, given where we are and given what, I think folks closer to my side look at when they look at the court right now. I mean, if a 6-3 conservative majority still isn't enough to achieve that goal, first, I think that's conceding that the goal here has a political bent, not necessarily a legal principle bent. But second, I also think that that's that's not an indictment of progressives. I think that's rather an indictment of the conservative legal movement writ large. But I also think it's worth stressing, Hugh, that, one way or the other, I mean, Jonathan talks about the what he calls the corrosive effect of Roe on other areas of the law. Obviously I disagree with that, but I do think it's an important point that Roe does affect other areas of the law. And one of the things that's been remarkable to me, especially this week, week 2 of the leak story, has been how a number of folks who were so sure last week that the leak was coming from the left have shifted to criticizing people like me who have worried that the Dobbs draft opinion, if it actually makes it into the books, would be a blueprint for other states to try to challenge precedents on contraception, on, private sexual intimacy, on same-sex marriage. If I don't think you can have it both ways. Either this is only about abortion and we're going to get a sui generis decision with no implications outside that context, or it isn't, in which case folks who are worried not just about what this means for reproductive rights in this country, but for lots of other rights we've come to take for granted, are not, in fact, being alarmist and are, I think, quite properly raising the right hackles.
Before I throw it to Jonathan, let me both agree and disagree with you. It is an indictment of the conservative legal movement through 1992. Then it got its act together and began to figure out that the Souters and the O'Connors and the Kennedys are not the kind of candidates you want. But I do believe Roe is sui generis. I do think it is one of a kind, and I do not believe there's any threat to Obergefell. I don't think there's any threat to Griswold. I think that's all silly. Jonathan?
Well, yeah, I agree that those threats are exaggerated, and that's because to get the overturning of a precedent, especially a precedent like this, you need a combination of a bunch of factors. The original decision being, as the draft opinion characterizes it, egregiously wrong, is but one of the things that you need, both legally and just as a practical matter, for a decision to be overturned. And I don't think the other cases that Steve mentions involve the constellation of all of those factors. And for that reason, I don't think that precedents relating to contraception and the like are at risk. There may be individual state legislators here and there that would love to challenge them, but you need to get laws enacted. You need to get those laws upheld by lower courts, and then you need the Supreme Court to take those cases. And that's just not going to happen. There aren't going to be 4 votes to take these cases or 5 votes to overturn.
It's already happening as well.
Steve, let me ask you about the 2 parts of the Alito draft about which I think Jonathan is right. One is reliance. There is not reliance in Roe and Casey, but there is in Obergefell. And the other being political stability. Political stability arrived on both same-sex intimacy and marriage and on contraception long ago, and it's not going to be disturbed. That has never arrived. And so it is a category of one.
I vehemently disagree with both of those statements, Hugh. I mean, the notion that, there's no reliance in the abortion context is a rather shocking thing to say to millions of American women who have made professional choices, who have structured their lives around the assumption that abortion access will be meaningfully available in the states they live in. And I think we're already seeing fear that the end of Roe and the end of Dobbs is going to upset that calculus and is actually probably going to lead to an exodus of women of childbearing age out of red states. To the point about the other precedents, I mean, guys, there's only so much time we can spend ignoring what is actually happening on the ground. There's a bill that has been introduced in Louisiana that has strong support in the Louisiana House, not from a band of outlier state representatives that would ban particular forms of intrauterine devices, IUDs. That's a direct assault on Griswold. I live in Texas, unlike Ohio, where we have a state legislature that, among other things, is not just severely partisan gerrymandered in favor of extreme conservative views, but that loves to push the envelope, and that is set to meet in its next session in January of 2023, where there's already talk about pushing back on precedents that we thought had been well established, precedents like Plyler versus Doe and the right of undocumented immigrants to attend public schools. So I just think that it's easy for folks who live in states with more moderate politics or for folks inside the Beltway to tell themselves a story that this is just about abortion. Guys, it's hard for me on the ground in Texas to look at what's happening around me and say that we're not going to see the kinds of political circumstances Jonathan says are necessary predicates. It seems like we're just denying what's in front of our very eyes. If we,
but Jonathan, the Louisiana law, as an example, has been denounced by every pro-life and the Catholic Church activist out there. It is an outlier. It ought not to be dressed as other than an outlier. So how do you respond to Steve's parade of horribles?
Well, I mean, as I said, there will be bills introduced by individual state legislators, and there may be the occasional bill that was passed. I mean, before there was a court majority that would consider overturning Roe, there were all sorts of abortion laws that were passed and proposed in various state legislatures that we knew could not become law unless the court was willing to overturn Roe. Similarly here, you may get an outlier law passed here and there. It will not get upheld by lower courts. It will not get accepted for cert by the Supreme Court after struck down. And that, again, you need is broad constellation of factors. It may be that for specific precedents, you may get one here, one there, but the entire constellation, many of which are discussed in the draft opinion, and then many more that are a function of, as a practical matter, what it requires to get a case teed up for the court and for the court to accept. And again, abortion has been something that has where folks have been trying to line these things up for decades. That is simply not the case in these other contexts.
Steve, you get the last minute. I want to give Steve Vladeck the last minute because it's kind of 2-1 here today. Steve?
I mean, listen, I hope you guys are right. I mean, for whatever else might be said about Justice Alito's draft opinion, a world in which what to me is the damage it does is limited to the abortion context is better than the alternative. So I want to believe you guys are right. But when some of the same people, and I'm not suggesting you two, but when some of the same people who insisted that Roe and Casey were safe, the Wall Street Journal editorial page, for example, as recently as July 2018, are now yelling at people like me for having the temerity to suggest that an opinion getting rid of Roe and Casey would have no further ramifications outside the abortion context, I don't think it's unreasonable for people who don't have your political views to be a little nervous that that's not true and to look at what's happening in Louisiana, in Texas, in Alabama, in Idaho, and worry that the constellation of political circumstances that led to the growing support to overrule Roe and Casey is going to lead to similar support to scale back other precedents as well.
We will be back with the smart guys in a few weeks when Jonathan Adler and Steve Vladeck come back to explain the final holding in Dobbs. Thank you both, Professors Adler and Vladeck. Don't go anywhere.